Hello, this is Erick Widman from Passage Immigration Law. We are doing our weekly live Q&A broadcast here, and we have some great questions that have been submitted. And two people actually asked about this concept called immigrant intent. And this comes up a lot because for many visitors to the US, you're not allowed to have immigrant intent. So one of the key things that we want to answer for you is what is immigrant intent and who does it impact? And particularly the one individual is wanting to know if someone can come in and get a green card after entering on a visitor visa. So certain types of visas require that you have non-immigrant intent, that you do not have the plan, the intent to stay for the long term and apply for a green card and adjust status. But in some cases, it is okay to develop immigrant intent later on, but it has to be legitimate. It has to be a thing that you don't pre-plan, because it's visa fraud if you plan to adjust status. You cannot do that. But if you're someone who comes in on a visitor visa and your fiance proposes to you, for example, and you decide to get married later, in many situations this is okay because you are developing immigrant intent later than the time you enter the US. There's something called the 90-day rule, which requires that you don't take steps that show you have immigrant intent within 30, 60, up to 90 days. But after the 90-day period, there's a presumption that you did not have immigrant intent if you got married, adjust status. So overall, like so many aspects of immigration law, it can be rather tricky to determine, something of a gray area to determine if you have immigrant intent or not. But you are well served to look carefully at your own unique circumstances and see if it's possible for you. In some cases it is, in some cases it is not possible to adjust status. Okay, that was a bit of a preamble here. So one of the next questions is, what is the best way to get my brother to live here in the US? And for your sibling, unfortunately, the spot in the visa bulletin is quite low and slow compared to the other categories, which are also rather slow and delayed. But if you go to the visa bulletin online, and I'll do that here as well, you type in visa bulletin into our friend the Google, and you will see that every month they update this chart. The US State Department updates the chart showing how long it's taking on average for these different preference categories, they're called. And so I pulled up the visa bulletin for February 2022, and in the family sponsored preference categories, your brother's category is F4, F as in Frank, brothers and sisters of adult US citizens. Because if you're a green card holder, you unfortunately cannot petition for your sibling. You have to naturalize, become a US citizen before you could petition for a brother or sister. But if you look at the F4 category on the visa bulletin, you'll see that the wait period is quite lengthy. And the date listed for the cutoff date for the F4 category, March 22nd, 2007. That date means that all the petitions filed after March 22nd, 2007 are cut off, and they're not eligible for a visa number. So basically, Only people who filed in March of 2007, March 22nd, 2007, or before can proceed with the consular processing steps to move forward for that sibling visa. The sibling can apply with the DS-260 visa application on that date or earlier when your priority date is at that date. Also, there's a bit of bad news that the bad news keeps getting worse, I suppose. For some countries, India, Mexico, Philippines, China, those are highly impacted countries, and the wait time's even longer. So for Indians, for petitioning for their siblings, the cutoff date for the priority date is 2005. And Mexico, sadly, is worst of all. Back in 1999, you have to have filed a petition at that point, April 22nd, 1999 or earlier, before your sibling is eligible for a visa and can apply for that. So the best way to petition for your brother, if you're a US citizen, you could start that process. In some ways, it's like a retirement plan. And depending what country he's from, it can take 15, 20 years. But you could do it because you simply have to file an I-130 to start the process. Costs $535, I believe. And you at least get that petition filed so that if he can't come here sooner somehow, that will be an option for him later on. You can also look for your brother at alternatives, such as a business-based, employment-based visa, or some kind of study abroad program for him. He could come as a student, get an F1 visa, or pursue a J1 visa, which many students or professionals can take advantage of. Unfortunately, siblings, it's pretty rough to get a visa in a timely way as a sibling. And you should definitely look at another option too. If you have a family member, a parent that you could petition for the mother or father who gets a green card, and then the parent would petition for your sibling. That is often faster than waiting for the F4 brother or sister category to come through. All right, moving along with the next question. Okay, I'm here in the US with an EB3 visa. Can I bring my mother here with me? And if yes, what kind of visa should it be? So if I understand this correctly, your company is going to be getting you a green card in the EB3 category. And oftentimes that involves a perm and a labor certification. So in the meantime, you need to have some kind of underlying status, and you're wondering, can you bring your mother here with you? So in order to petition for your mother, parents need to have a petitioner who is a citizen, similar to only US citizens can petition for brothers and sisters. So you would need to become a US citizen to petition for your parents. Now, in some cases, there are alternatives, but not often very good ones. And your mother would have to look at some other options too. I'd encourage you, we need to know some more details. I'm going to give you the support email address, support@passage.law. Please send us an email and give us more details about your status and your mom, and whether she's had a visitor visa before or come here before, and what her status is, and whether you have any options for citizenship. Okay. What happens with my immigrant status if I get divorced after getting my temporary green card, but before my 2-year interview for the permanent one? Also, does it matter if my husband is verbally and emotionally abusive to me? Well, very sorry to hear about that. as all good immigration lawyers will tell you, make sure you're safe, and the top priority is getting away from any abuse that is unacceptable. Of course, any abuse should not be allowed, but you have to make sure you're physically safe, and you take steps to protect your mental health too. So what happens if you're getting your temporary green card? You got your temporary green card, so it's a 2-year green card, but you get divorced before that removal of conditions happen, before the permanent green card, the 10-year green card, and that's through the 751 removal of conditions process. All right, so this happens sadly quite a bit, where a couple will get married, and you, the foreign national, will get a temporary 2-year green card, and then to remove conditions and get a permanent green card, you have to go to an interview with your spouse, and then if you're applying through the standard joint process, joint application, and you're still together and your marriage is doing well, you're able to get a 10-year green card on that joint filing basis. Thankfully, there's another way to get a permanent green card, even if your marriage doesn't work out. Even if things fall apart, you're able to do a waiver filing for that 751 form. And this, again, is quite common because 50-60% of all marriages don't make it. But on the 751 form, you, at the very beginning of the form, you need to check the box, whether it's a joint filing or a waiver filing. And what you'll have to show to USCIS is that you had every intent to keep going with your marriage, and that you had a plan and a genuine desire to live with your spouse for the long term, but it didn't work out. And so you had the intent to build a life together, but based upon various reasons, things fell apart and you had to get a divorce. For USCIS to approve your 10-year green card, you're going to want to provide them the divorce decree. You're going to have to give them a copy of that finalized divorce. And many times they'll send you a request for evidence, or they'll just be waiting for that to happen. USCIS will have to get that in hand before they can renew and give you a 10-year green card. So that's a common challenge, is getting that divorce decree. Sometimes there is a VAWA option, Violence Against Women Act, VAWA, and that's another way forward in some circumstances. Okay, moving along. When can I file for citizenship for my children and wife? Which form can I use for the kids? All right. So if you, we should definitely ask to find out your status, but your children and your wife need to be permanent residents, so they have to have a green card. And then depending on your status, if you're a US citizen or not, that will impact, for example, your wife's timing. And so your wife, if she is married to a US citizen, can naturalize in 3 years. And you're actually not involved in filing for that. You don't have to petition for your wife. That's an application coming from her. So your wife would file for citizenship on her own. But if it is on the basis of her marriage to you, the faster time period in 3 years of being a permanent resident, you're going to need to show that you have an ongoing, genuine marriage, that you have a genuine relationship, you're still living together, you're not divorced, for her to take advantage of that 3-year period. So otherwise, there's a standard 5-year period that is the default for applying to naturalize. And in that circumstance, if you have the ability, if it's already been 5 years that someone's been a permanent resident and they could apply on their own, or they're also married to a US citizen, the best thing to do is, and the easiest for the N-400 form, is to simply file on the basis of your own status yourself as a 5-year green card holder rather than on the basis of being married to a US citizen. There's less proof, there's less documentation required, and there's no need to file on the basis of a 3-year period with your US citizen spouse unless you're trying to get it done within 3 years of being a permanent resident. So if it's over 5 years, just file on behalf of yourself. And for the kids, this gets more complex, and I don't have the regulations right in front of me. I wouldn't want to bore everyone with pulling it up, typing it up. So I would encourage you, I'd be happy to pull this up by emailing us, support@passage.law, and we'll let you know. There's also an N-400 for the kids. Sometimes, according to the Child Citizenship Act of 2000, once you become a green card holder, your kids under a certain age, if you will immediately naturalize too. If they get their green cards, you're a US citizen, then they can also immediately derive citizenship. That is exciting. And then they would go with an N-600 form rather than having to use the N-400 because they're already citizens. They would file an N-600 to get a certificate of citizenship that would prove that they're already citizens. So yeah, I'm happy to get back to you on the details of this, where we could do an email exchange. Let me know more details about your situation. And there we go. We got to cover a lot of ground today. Let us know if you have any follow-up questions. Send us an email or give us a call at our main number. Take care, everybody. Good to see you. Bye-bye.